Good morning.
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 We've got people still coming in, so it'll take a couple more minutes.
Carolyn, I know they're trying to get it turned on in the training room. There's new agents in there.
Uh-huh.
How was your birthday, Marilyn?
We got 2.5 inches of rain.
Oh, so you got a blessing on your birthday.
Yeah. I mean, it came down so fast and so hard. One of the delivery people literally was soaked, and so was I, trying to get the delivery. And we're just not used to rain, obviously. So
Well, you haven't had any in so long. I'm glad you got some up there in the hill country.
yeah, and we didn't get enough. We still need more. Thank you very much. Yes, it was a huge birthday. I had family, and we celebrated for almost a full week.
Oh, awesome.
People from out of state, all over the place. So it was really lovely.
Good. Let me check on the training room for you and let you know if that's up.
Okie doke. Thank you. Okay, we're going to go ahead and get started because I don't want to keep you too long, but we've had really long sessions with all of this. Welcome, everybody. I hope everybody's doing well. What we're going to do today is we're going to analyze an offer, and it's through the eyes of both buyer agent and listing agent. But before we get started on that, I've got some information to share with you. TREC is literally revising every contract form, almost all the addenda, and even in the amendment. So what does that mean for you? It means that you will absolutely have to stay connected the next few months. Everybody needs to be muted. If you need to ask me a question, just take yourself off of mute and interrupt me. But again, this process, TREC did approve some that are mandated by Thursday, September 1st, and we're going to look at those real quick. All the seller's temporary residential lease and the buyer's temporary residential lease have been modified to include that now you have to attach the residential rental flood disclosure. You can use either the TREC one, or you can use the Texas Realtors one, because the Texas Realtor ones, they've had those out there for quite a bit. If you have a question, just take yourself off of mute and ask me. Somebody has their hand up.
I lost the sound. Can you hear me?
I can hear you now, yes.
Okay. Now I lost your video, but I can hear you. Okay.
So you have your hand up. Do you have a question?
I just couldn't hear.
Oh, okay. Just mute yourself. And as I said, if you have any questions, take yourself off of mute and then just interrupt me while I'm going. What I'm going to show you right away are the changes that are effective as of Thursday. No forgiveness on this. It is a violation not to use a current form, and these are TREC promulgated forms, so you have to be very careful about that. Both the seller's temporary residential lease and the buyer's temporary residential lease were modified. Besides the little lines that they gave you in special provisions, it was modified in paragraph 23. It says the landlord's floodplain and flood notice pursuant to Texas Property Code as delivered to tenant, landlord's floodplain and flood notice. Now, who is the landlord on a seller's temporary residential lease? The buyer. And you're saying, well, the buyer hasn't lived in the property. How does the buyer know? Oh, yeah, they have a seller's disclosure. And whatever the seller has disclosed, that's how your buyer, who will be the landlord and will complete the flood disclosure, will do so. Okay. So again, as of Thursday, that's the 1st of September, no forgiveness on this. It has to be done. Buyer's temporary residential lease, they did the same thing, right? In this instance, who is the landlord? The seller. Okay. So the seller will complete the disclosure, either the TREC disclosure or the Texas Realtors one. But these are mandatory for use as of Thursday. So if you have any offer that's been presented on Thursday and there will be a temporary lease, what would you recommend? That they use the current form, the new form as of 9/1, and attach the floodplain disclosure. Now, this is the Texas Realtors floodplain and flood notice. Okay. As I said, you can use the Texas Realtors one. This is the TREC one. TREC does not mandate this because they were behind the 8 ball and they didn't realize that it applied even to temporary leases, the law. But Texas Realtors was on the spot. They had one as of January of this year, and it's Texas Realtors 2015, or you can use the TREC one, whichever one, it doesn't matter. When TREC says it's voluntary, that means most likely there is a Texas Realtors form that's already used. Okay, so again, that's what we're going to be looking at. Now, before we get started on analyzing offer, I said, hold on to your hats, and I really mean it. I'm going to go through a couple of the changes on these things. We're not going to spend a lot of time today. We're going to be in preparation for approval by TREC, hopefully in November. And then we will absolutely be going gangbusters on training on this, because as I said earlier, it is a violation for a license holder not to use a current form. Okay, and they all, everybody wants to know, well, what does that mean? Well, that means that if somebody turns you in, TREC looked at the transaction and all the documents, you would be considered in trouble. So again, we don't ever want that. We want only the current forms to be used, period, on everything. But what I'm going to show you are a couple of changes on the 1 to 4 that will have significant impact on you as realtors. Okay, number 1 is in paragraph 3, sales price. They actually define what the cash portion of a sales price, because we had too many buyers in the last few years that were committing fraud. They were not being truthful with the sellers when they were actually using hard money lenders and other financing means, but they put in that they had cash. Problem. Again, we had a lot of issues. Lenders were even telling our buyers, don't do the addendum for sale of other property. We'll take care of everything. When those proceeds from the sale of the other property were in paragraph 3A, that was a big no-no for a buyer to do that to a seller. Does a seller have a right to know if you're financing or not? Amen.
Yes.
You know what cash is? Cash is liquid. Cash means that buyer has in their sole possession right now those funds. period. It's not that they're going to liquidate a 401 or they're going to get it from something else. No, absolutely not. I know what cash is, and so do you. It's not a promise I'm going to liquidate something. It says I have it at my disposal. I have verified that I'm able to withdraw it. I have verified that it will not take, I'll be able to close by the closing date and have those funds. So it says the cash portion of the sales price does not include proceeds from borrowing of any kind or selling other real property except as disclosed in this contract. And this contract would have what? Either a third-party financing addendum that they're getting borrowing of some kind, or it could be they're getting proceeds from the sale of another property, the addendum for sale of other property. This was important because, as I said, too many complaints were brought forward. Sellers felt that they had not been treated fairly at all by the buyer agent, that they were all in collusion to conceal a material fact. That's a very serious consequences for you as an agent.
Marilyn, I have a question, please. Because a few months back, in one of your meetings, we talked about the buyer's right to change the terms of the financing on the third-party agreement. Has that gone south?
No, they're defining what cash is,
Okay,
but cash portion of the sales price. It's
So-
nothing that they can always
I'm-
be amended.
if I'm representing a buyer, right, I can say, I'm gonna put down $100,000 on this home, and I can go back after the contract's accepted and change it,
Sure.
which was,
We have lots of buyers who do not close based on the terms in paragraph 3.
right, and when does that need to be disclosed and how?
Well, most lenders usually want an amendment showing something. Certain financing, FHA and VA require most likely a revised third-party financing addendum signed by all parties and a part of the contract. But the buyer has the ability at any time, because it's on paragraph 1 on the amendment, so they can provide those details to a seller at any point in time.
Okay,
I'm going to tell you that most do not.
sorry.
Most do not. As I said, if you went back and found out how many closings we had, none of them closed based on terms of paragraph 3. There was some modification of some sort. But the critical part here is the buyer better close by the closing date. That's the critical part.
Okay, I'm just wondering, since there's so much talk about the way this is written, if something changed on the third-party finance.
Now, this is about cash portions. They had to define it because too many people were misusing it.
With hard money.
Hard money coming from other places. Buyers were told by lenders, don't put an addendum for sale of other property. And yet the monies they put in paragraph 3A were actually proceeds they would receive from the sale of another property. That's where a majority of the issues came from. And as a buyer's agent, that would never be acceptable.
Okay, and just because we're gonna have more of them that come up, when it is a hard money loan, how do we find this on the offer? And on
It's in the third-party financing addendum. It's being revised, and I'll show you that briefly as well.
Okay, thank you.
Mhm. Okay, the next big part, besides the escrow agent being capitalized and survey being lowercase now, is the issues about the notices. They added a new paragraph in 6E that says the following notices have been given or are attached to this contract. For example, MUD, Water Control Improvement District, PID notices. Any of the notices that are required by law for a seller to provide it to a buyer and have a buyer sign it before the executed date on the contract. They have now added a paragraph for that. Why is that important? Well, we told TRAC people are sticking notices in the agreement of parties in paragraph 22, and that's not where they belong. Okay, so again, this is the acknowledgement that there are these notices that are statutorily required by a seller to get a buyer to sign prior to the contract's executed date. So they've added that paragraph. Now, the next one that's going to cause a lot of problems is something that has always had to be done, but we had too many complaints where listing agents were not assisting sellers in complying with the terms of the contract, and buyers agents were failing to assist the buyers in making sure they get all of the documents that are necessary for a seller to prove that they have made any repairs or treatments for the contract. So the paragraph says sellers shall, 1, provide buyer with copies of documentation from the repair person or persons showing the scope of work and payment for the work completed. And 2, at seller's expense, arrange for the transfer of any transferable warranties with respect to these repairs and treatments or any negotiated in the contract to the buyer at closing. As I said, this is not something that you have not been fiduciarily obligated to, but we are seeing that more complaints were filed because listing agents didn't help the sellers comply with it. You have to have all of this prior to the closing date. You don't get to give it to anybody on the closing date. That's already, the seller is already in breach of the contract. So again, this is going to be a big, huge step. There is going to be such a big step on this that the broker is going to have to require, now that these documents, any amendment for any repairs or treatments, you would have to provide those paid receipts uploaded in order to get your DA and be approved. Because the broker responsibility rules are very, very finite. They said you have to supervise and make sure that everything's done properly. And so it's going to cause a major ripple. When agents are not used to it, they weren't trained properly to always do this. I knew this, and I got my license in 1993. So it's just a lack of procedures and processes that the agents kind of let slip. And it has caused major problems. And now the language is very clear. I am going to tell you that if a seller does agree to any repair and treatments, the language for showing the scope of work on that paid receipt better be exactly what the parties agreed to in either the contract or in an amendment. The exact, it's going to have to say exactly the same thing. Otherwise, the buyer's going to think what? Seller didn't complete the agreed upon repair treatment. Real quick, because I spent about 30 or 40 minutes talking to somebody about this, here's what happened. And we've talked about this before with amendments and how they're used and how they're have to be very specific instructions, because the seller has to know clearly what is it that I'm asked to do, right? Because now they're going to be showing it to anybody who it comes to do that repair or treatment. You've got to do this, right? Here's what happened. The buyer asked the seller to do certain thing. Seller called out somebody, and the plumber says, there's nothing wrong with that. The seller still have to make that repair? You better believe. Or an amendment would have had to be done between the parties, modifying that first request for that repair or treatment or removing it. Be very careful. Buyer's agents, that's exactly what is needed. That's why buyers don't close and go after sellers for not having completed all the agreed upon repairs. And listing agent, the minute you are aware of this, you have to do something about it. You have to get an amendment between the parties. And if there's no amendment, the seller has to do it. No ifs, ands, or buts. The problem is we're going to have a lot of these situations where sellers are going to either reduce the sales price, or maybe if there is a concession that the parties can mutually agree upon for settlement expenses subject to third party, if the lender is involved. If there is a cash transaction, you're going to take it off at the sales price every time. But make no mistake, it's going to be done perfectly, or you're going to be in trouble. Okay. So again, be very careful about that issue. Now, real quickly, I'm going to show you something about paragraph 9, where they added that private transfer fees, and you have lots of subdivisions out where you are that have these private transfer fees, will be the obligation of seller unless provided otherwise in this contract. And what does that mean? It says it doesn't have a fill in the blank here. So special provisions would have to be used for a material fact that either buyer and seller agree to split the $5,000 private transfer fee at closing and funding, something that would do that. Otherwise, your seller is going to be obligated. So you don't take a listing unless you make sure every T is crossed and every I is dotted and that you identify any private transfer fee. The reason they had to add this is because the addendum for mandatory membership in a property owners association has changed. The next one is special provisions. I don't know, I cannot tell you how many hundreds of thousands of times I have been called over the past decade or so, where the agent will say, help me with the language. Well, I'm not going to help you with the language because now it's real clear. It either comes directly from your client or their attorney. You can only have informational items or an additional item that completes a blank in a contract form, just like I said, paragraph 9, talking about that. But you are not going to add anything without it coming from your client first. And the reason for that, truthfully, is when they send you something and you said, ooh, this conflicts with this part of the addendum, this conflicts with the contract, you now need an attorney to give you advice. The reason I say that is, I don't know about you, but do you want to have a contract where you already know there's going to be a dispute? No, our job is not to cause problems. Our job is to help our party that we represent at a very high fiduciary level to get to the closing, right? That's what our job is on something like this. And when you know there's a conflict, you can't let that go. Now, if the buyer or seller's attorney said, I'm fine with it, oh, baby, you better keep that communication because that has to come to you in writing from the attorney, period. Okay. So again, they're just being very clear on this because we had too many agents that were practicing law. And I can always tell when the language comes from a buyer or a seller or their attorney and when it comes from the agent. So it's really hard. And you know why? Because under testimony, we've asked many buyers and sellers, when did you provide this language to your realtor? And they said, I didn't. That realtor came up with it on its own. I had no idea it was going to cause a problem. I had no idea that we couldn't have appraisal language. I didn't know any of you, they're blaming you. So again, they're going to be very clear on the promulgated form so that even buyers and sellers can read and realize that agents can't provide any of that information. You can bring it to their attention, then they'll draft whatever they want. Now in prorations, they changed something. They said they added rents and prepaid regular periodic maintenance fees and dues. They are the sellers through the day of closing, right? Everybody knows that, right? And the reason they did that is because I'm going to show you very quickly on the addendum for mandatory membership, the information that is being proposed to be changed as well. And then I'll show you real quickly the financing addendum proposed changes. Okay, in paragraph C, we had more title companies that were getting instructions from nations. These are the fees. These are the reserves. And many of those fees were prepaid items, which no seller was ever obligated to. But man, title companies said, nope, we're going to follow the HOA's instructions and we're going to charge it to the seller because the buyer said they're going to pay $50 and seller will pay the rest. This is not about private transfer fees. That's already covered in the contract. So these fees and deposits for reserves, except for prepaid, regular periodic maintenance fees, assessments, or dues, or as provided by paragraph A and D, buyers shall pay any and all association fees, deposits, reserves, and other charges associated with the transfer of the property not to exceed X number of dollars, and sellers shall pay any X. There is a $ in front of this. If you start writing all every time, you're going to have to be supervised in every transaction going forward, because I don't know about you, but when you see a $ and a fill in the blank, what has to be there? A dollar amount.
A dollar amount.
You don't put the word all or TBD. You can't use any of that. And you either are going to learn how to use these forms properly, or the broker is mandated to step somebody in to supervise you. And that's not going to be acceptable when you've been an agent practicing real estate for 10 years. right? That should never have experienced agents. They know better. Here's this paragraph that changed. Prepaid regular periodic assessments or dues required by an association are due to be prorated pursuant to paragraph 13 of the contract. What did I just tell you? That all the seller's fees are theirs through the day of closing, right? Prepaids are what the buyer would pay as an owner, and they are not through the day of closing. Those assessments only kick in when they're the owner, and that's what has been wrong. And it says this paragraph does not apply to a fee that is not imposed by the association, even if it is collected by the association for the benefit of the third party. And that's exactly what happened. Those HOAs were sending over instructions to title, and the escrow officer was looking at them and said, okay, buyer's only going to pay $50, seller has to pay these $2,000. No, prepaids have never been a part of this paragraph. They've made it very clear here. Prorations are based upon what are the seller's obligations only through the day of closing. And we're very grateful that they finally listened to us, and because we turned in all the title companies that were doing it wrong. Our sellers were punished at the closing table, and it was, title is not going to interpret anything, right? Title was looking at what was given to them, and even though the association was saying this fee has to be paid, it wasn't a fee from the association. It was they were going to filter it and provide it to a third party, but it wasn't an association fee. Those fees are very transparent now. They are up on track. Buyers can look at them before they make an offer, and listing agents should look at it with the sellers before any documents are completed for a listing, period, on something like that. Okay, the next one is we are going to look at the third-party financing addendum. Amendment change too, because it's reflective of what changed in paragraph 7F of the contract. Okay, here we go. They added a paragraph in paragraph 1G, other financing. Remember I told you about third-party hard money lenders, parents that are giving the money? It says a loan not of a type described above from so-and-so, the name of the lender. Could be even the parent's name on there. In the principal amount of such and such, due in so many years, not with an interest to exceed something for the first 3 years, origination fees. Buyer does or does not waive all rights to terminate the contract under paragraph 2B of this addendum for the loan described in this paragraph. Why is that? Well, we had situations where the parents said, I don't care what it appraises for, I'm giving the money to the kid. So they were waiving 2B. As a lender, the parents said we were waiving that. The hard money lenders do not waive that because it is a requirement. 30 years ago, they waived it. They didn't care because they were getting all this interest from the borrower that they didn't care if it appraised or not. They felt that was on the part, the burden on the borrower. But this is what's proposed because we've had too many situations where the cash portion of the sales price was really money coming from other sources. And quite frankly, when you have a seller that receives an offer and they're saying they're paying cash, you have to have proof of funds. Remember how we talked about cash? What is cash? It's liquid. It's in the control of the buyer. There's not a seller on earth that would have ever approved an offer if the buyer didn't have the funds. Because these parents, let me tell you how many times I've been called. The parents said they were giving money and then their mother got sick and they had to use that money for the mother. So now the buyer's in default of the contract. So be very careful, listing agents. Your sellers really need to know the source. No seller, you would never recommend a seller agree to an offer where the buyer wasn't in control of the funds, if it was cash, or that they were financing and they didn't have a conditional approval letter. Right? Those are just
Carolyn, I have a question. Sorry. So the buyer is getting a gift letter that's approved through their lender, does that have to be disclosed here?
It better be on the conditional approval letter.
That there's a gift that's coming from a third party?
Amen. The conditional approval letter, that lender has verified all the funds, and if they're gonna have to have a conditional approval letter, and they would have to state that it would be contingent upon what? The gift letter from the seller's brother, sister, whatever.
Sister, yeah, whomever,
Mhm.
yes.
Yeah,
Okay,
That's
but
it.
it does not belong in this part of the third party
No.
financing,
no.
right? That's
No.
between the lender and the buyer.
Mhm. But a seller should know that there's gonna, in order for this buyer to qualify. the
Oh, I agree with you. I think somebody needs to crack down on lenders' letters because
Well,
there's
the conditional
a
approval
lot of
letter
leeway.
is more detailed. The lender is required to have looked at the funds, the cash to close and all those different things. And they have to list what is the conditions. If it was conditioned for a sale of a previous property, or if it was a condition upon a gift letter. Every good lender would put that in the conditional statement. of
President, I
approval.
have a question.
Okay,
How you doing? Hard money lenders. Does it apply for them?
third-party financing has always applied to hard money lenders because it's the only place in the contract that we have a provision for appraisal in 2B. While the buyer may not be subject to approval of terms or individual approval, make no mistake, any third-party lender was on the contract on the third-party financing addendum.
Okay, thank you.
Mhm. Okay, so lots of changes coming. I'm telling you, you've got to stay plugged in because the broker laureate committee meets in October. If they put their stamp of approval on all these revisions, and there have been meetings back and forth between TREC, the broker laureate committee, over and over and over in the past year, that TREC will meet again on November, I think November 7th, and they're going to approve these. They'll be mandatory, most likely for use by January 1. Okay, and so we're going to go through them and those type of things. But now we're going to go to really.
Me again, Marilyn, before you move on, are those revisions available for us to go in and make comments on the TREC website at this time?
Yeah, you have a very limited window. It ends in sometime in early April, but yeah, you can go in and make comments to TREC.
Okay, perfect.
Okay. And TREC reads all of them, just like we did on the Texas Realtors Task Force. We read every comment, even as ridiculous as some of them were. We read every comment and we took it to heart, and if it was going to be part of our consideration. Now, what I'm going to do is kind of analyzing this as an offer we've received, right? Sometimes I'm going to talk about it in reference to what a listing agent better be prepared to do and what a buyer agent should be prepared to do. The first thing, parties, here's the deal. It says Jane Doe in the estate of John Doe. Jane Doe is alive. Do you know how many agents get this wrong? There were 2 individuals are owner of record. One of them passed away, one is alive, and yet they put the estate of John Doe and Jane Doe. No, Jane Doe, it's not her estate. So you want to make sure the person who's alive is first. Who legally has authority to settle the estate of John Doe, you better provide in writing. It better be uploaded and it better be coming from the courts or some authority that has said this individual can exercise the rights to settle this estate for John Doe. Bottom line is you got to have that. You have to have that at time of listing. Do not go forward and get into a contract and have all these issues and disputes. The buyer is Excalibur LLC and or signs. Well, buyer's agents, you better have the articles that prove who can sign on behalf of Excalibur LLC. And oh, by the way, you better make sure it is active, the Secretary of State. We've had an agent, unfortunately, that put in an LLC that was not in existence. And of course, now we have an issue. Buyer agent just took what the buyer said to them, or they misunderstood what the buyer said. They didn't get it properly, all these kinds of things. The big thing is and or assigns. That's a big humongous red flag for a listing agent. And we'll talk about that a little bit later. So I'm a listing agent right now pretending. I got a little list here of all the issues that I'm going to run through as I go through this offer. And this is how you do it. The next thing is property. You better check the legal description, listing agent. It better be exactly right. Address,
I have a question.
yes.
Okay, on the buyer side, buyer agent is responsible for find out the LLC on the list. If I'm the listing agent, do I need to verify also?
You will need to get verification from the buyer agent in writing prior to your seller accepting an offer. Do you have proof that so-and-so can act on behalf of Excalibur LLC?
Isn't it title?
And if the buyer agent doesn't respond properly, the buyer agent could be in trouble.
Okay. Isn't a title company,
No, when you represent a buyer, that's your,
no, if I'm representing listing agent.
you have to know this is a legal entity. You have to have a copy of their articles. You have to know that this individual who will sign on behalf of this LLC is in fact legally able to. And oh, by the way, you need to verify the Secretary of State, the status of that LLC.
Okay. Thank you.
Property, that's really important because legal description is really what most everything is pulled from, the survey, the commitments, all these things. From time to time, we do have mistakes, but man, it's a glaring mistake. I blame listing agents and I blame buyer's agents if you get it wrong. You better correct it as soon as you know in a amendment. Otherwise, one party would say, hey, I put an offer and got a contract on a property that doesn't exist or that the seller doesn't own. Oh my Lord, you will be in so much trouble. So cross the T's and dots the I's. At this time, you take a time to look at what is provided in the appraisal district for the property. Now, the next thing on the paragraph, as a listing agent, chandelier and dining room. Well, they understood what I was asking the buyer to make sure that they understood the exclusions. The chandeliers are part of real property. They're in 2B of the contract, right? I want somebody brave to take themselves off of mute and tell me, what would you tell your seller if at the listing appointment, the seller says, oh, I want to exclude the chandelier in the dining room?
Remove it.
I would
told
tell
her
my
to
seller
remove
to
it.
take it down and replace it.
Take it down. Yep.
You got it. That is the only way to go. And as I said, the problem is if you take professional photographs of real property, and a chandelier is real property because it's in paragraph 2B, the buyer would have every right to say, what? That's real property. You misled me.
False advertisement.
You got it. And all these different things. So in my world, there would be no exclusions like that because that's part of real property. Okay. I do know that people are putting washer and dryer and refrigerator. Well, those are not part of the real property, but I do understand they don't, buyer's agents just don't understand and buyers don't understand. But make no mistake, you as a listing agent want your sellers to do what? Provide the property in the condition they want the buyer to accept. Period. Okay. Okay, now, I see my first addendum that I'm going to need to see part of the contract. It's a third-party financing addendum. Remember, 3A plus 3B equals 3C. You are proficient in math and you better do that. The next one is paragraph 4, a residential lease. Why is this here? Well, it's here because the listing agent told the buyer agent, oh, the tenants are going to be out before this contract closes. We don't need that. Do not listen to the listing agent. They don't know what they're talking about. If there is a tenant in the property at time of offer, your buyer will attach the addendum regarding residential leases. And in that first paragraph, they're going to make the seller make sure that the tenant is not in the property at time of closing and funding. Do not listen to the other agent when they are wrong. We've had so many disputes over this in the last 2 years because agents just are forgetting that these addenda have to be a part of the contract. Okay, so now I have two addenda, third party and the addendum regarding residential leases. Okay. The next thing is we see earnest money and termination option. Yeah, everything looks fine. Notice I said freedom title because they are the escrow agent. Quit putting a person's name only as the escrow agent. That is negligence on your part. They are not the escrow agent. The title company is the escrow agent. The individual that works for the escrow agent is an escrow officer, assistant officer, whatever their title might be, but they are not the escrow agent. Okay, paragraph 6. Uh-oh, now my seller is going to probably have to send an invitation because they didn't mark a box of who's going to pay for the title policy, but they got the right title company, right? Yeah, this is a big issue. You don't leave blanks like this because this is negotiated between the parties and somebody's going to pay for it. So the seller's we're at the point now where probably going to have to send an invitation because you never know what crosses over when you're wanting to get something accomplished, but you still want your seller to be open to receive any offer and not have a counter. In paragraph 6A8, the buyer has said, I do want the shortages to read in the area and the expense of it, and I want the seller to pay for it. Well, you wanted the seller to pay for this, but you forgot to mark a box up here. Okay. The other thing the listing agent would have to know prior to any seller accepting it is what is that endorsement premium so that we can amend it to read the shortages in the area. Okay, there's a premium for that. And the seller would have to know that before they would ever agree to any offer. Now the survey, what we're going to pay attention to here is buyers going to get their own survey, and it says within what, 25 days after the effective date of this contract. Got to pay attention to the number of days. No days in the contract can go past the closing date. Okay, just remember that. No days in the contract or addendum can go past the closing date. Now the listing agent says, I've got a little bit more here I've got to take care of. The buyers are saying they have a right to object if they cannot use the property for residential rental, a daycare facility, healthcare facility. Who knows if the property can be used for those?
The HOA,
No, the seller knows.
municipalities,
Yeah, no, the sellers
counties.
know. Bottom line is that seller knows. And that's what I'm trying to drive in to you. The sellers all know. They all got all the documents. They know what their property can be used for or not. They may never have read them, but that doesn't mean they don't know. So what I'm telling you is if these are the kinds of activities that a buyer wants to use, a seller is never going to accept this offer without vetting that first and getting confirmation. Because they're not going to go under contract with a buyer, have a buyer spend all this money, and then the seller said, well, I knew you couldn't do a daycare facility. No, that's not how it works. And just because the buyer has asked for this doesn't mean the seller doesn't have a duty to make sure that these activities would not be prohibited. They need to do their due diligence before they accept an offer.
Marilyn, I have another question.
Mhm.
It's becoming more common to see VRBOs. And this is something that a lot of the HOAs are going back and trying to rewrite their bylaws.
Mayor's
Uh,
office?
So
Mayor's gonna be
their
on this
rules and
side.
I'm sorry. Marilyn, was that you speaking to me or somebody else? That was
Somebody
off?
put themselves off of mute. Everybody be on mute.
Okay, so my question is, if the buyer wants it to be a VRBO, how do we know for certain? Because there's a lot of HOAs that are trying to change those regulations.
Well, a seller will do their due diligence. They will contact them and verify, is something in the works that this is trying to be repealed or it's going to be changing in the future? Because anything they know They're not going to want a buyer to find out the seller knew that, but didn't tell them, and they closed and funded and then found out they could not use the property.
So as a seller, I would need to tell the buyer in writing somehow that at this time a VRBO is acceptable. However, there is controversy amongst the HOA in the subdivision.
Anything the seller knows, they can, that's a material fact, and that's a material fact. You cannot,
Where do we disclose that? Just in an email back to the buyer's agent?
I would think in the seller's invitation to buy to
Invitation,
an offer.
okay.
Mhm, they
All
would-
right,
Mhm,
okay,
mhm,
thank you.
mhm. Okay. Paragraph 6E only has one box to be marked, and that's where it says now the membership is not subject. So now I don't look for an addendum for mandatory membership in a property owners association. All right. The next thing that I'm going to see checked is in paragraph 7B. Whoops. You're supposed to check one box only and two boxes are marked. What is it? Right? That would be a correction on a seller's invitation. You have to have clarity here. Your sellers don't get to agree to something that you know is blaring. Paragraph 7D, same thing. It says check one box only. And instead of, they check two boxes. The buyer accept the property as is. And oh, by the way, the buyer accepts the property as long as the seller will do the following, right? It's one or the other, folks, not both. And here's what the buyer said to the seller. Seller to have the home professionally cleaned, professionally mowed, and trimmed 2 days prior to the closing. Would the seller have to provide paid receipts for the professional services to the buyer?
Yeah.
Yeah.
Absolutely.
Absolutely.
You got it. Now, the next sentence says, any lender required repairs. What's wrong with that?
That's
It's
pretty wide open.
redundant.
It's a violation to put that there, especially when Trex said do not insert general phrases such as subject to inspections that do not identify specific repairs and treatments. So the seller would have on their invitation, tell them to remove that because that's not something the parties know now. Those lender required repairs come when a lender doesn't send the appraiser out to do the appraisal. Okay, so a real big problem if a seller agrees to something like that. It's only what the buyer knows at this time. Okay. Now in paragraph 8A, it's complying with the law. And it says buyer is license holder in the state of Texas. So Excalibur LLC is owned by a license holder. They are required by law to disclose that relationship in writing. It belongs in paragraph 8A. Okay. Now here I'm looking at paragraph 9, closing is on or before 9/1. Whoa. So I'd have to look back at 6C too. It said 25 days. That most likely would have to be adjusted on the seller's invitation because again, we don't want any days going past the closing date. That's the kind of scrutiny a listing agent has to pay attention to with any offer that they receive. Now in paragraph 10, I'm looking, I think, oh, I don't have any temporary leases, right? Because possession to the buyer will be upon closing and funding. All right. The next one is paragraph 11. It says sellers are subject to FERPA. Well, as a listing agent, if your sellers are subject to it, you better get it all cleared up and your cute little net sheet will all reflect that prior to the seller going under a listing agreement. Why does the buyer need to know the sellers are subject to it? Well, because paragraph 20 of the contract requires the buyer to do certain things. And oh, by the way, any seller or listing agent that conceal that the sellers are subject to this and the buyer is not aware of it in writing prior to an offer or the executed contract, they're going to be in serious trouble. That's a material fact you do not conceal from any party. Again, because the buyer is subject to doing something in the contract in paragraph 20. Okay. Oh, yay, 12, nothing. Yay, yay. That's a great thing. Many of these paragraphs don't have fill in the blanks, but doesn't mean that they're not important for the parties to review. What I am going to tell you, I'm going to talk about paragraph 19 because this is the paragraph that should scare every seller to death. Okay, so as a listing agent, you probably are going to review this critically with them, even during the listing, because it says all covenants, representations, and warranties in this contract survive closing. If any representation of seller in this contract is untrue on the closing date, seller will be in default. Real clear. So seller wants to make sure that it is absolutely positive on any representations, any warranties, any disclosures, anything they do that will be absolutely true. And so paragraph 19 is why the parties sue. They said, oh, you knew this and you didn't tell me.
Huh.
You knew this, but you didn't put this on the seller's disclosure. You know, all these different reasons people get upset after it closes in funds. Now in paragraph 20, that relates back to what we saw in special provisions. That seller is subject to FERPA. They are a foreign person. So at this time, at the time of listing, when the seller is a foreign person, the listing agent needs either a statement from the CPA or the tax attorney representing the seller about the tax implication for this transaction. So what it says is that if seller is a foreign person as defined by the IRS, not direct, the IRS, or if seller fails to deliver an affidavit or certificate of non-foreign status to buyer, that seller is not a foreign person, right? Then buyer shall withhold from the sales proceed an amount sufficient to comply with applicable tax law and deliver the same to the IRS together with appropriate funds. It's important that the buyer know about this prior to having a contract, because the buyer has to know that when they have to take those proceeds from the seller and complete these IRS forms, they actually put their tax ID on it. So a lot of buyers say, I'm not going to do this. This is not the transaction for me. Okay. The problem is, if your seller is not a foreign person, they either have to provide an affidavit or certificate. Otherwise, it triggers what? That the buyer has to withhold. Plain and simple. I didn't make this up. You didn't make it up, but better have your sellers comply with it, because it says that the buyer shall withhold from the sales proceeds. So if the seller is not a foreign person, they're going to absolutely do the certificate or the affidavit, one of the two. Now notice this is never blank, never has been supposed to be blank. Many times listing agents and buyer's agents just want their information. That's not really per the contract. Paragraph 18 points to this. The reason Trek created this was because the agents weren't available and time of the essence was important. So a buyer had to communicate directly to the seller and provide a notice that would be time is of the essence per the contract or the terms of the addenda. So again, you didn't see the changes, but no agent will ever be able to have their primary notice. They are a courtesy copy only in the future renditions of the proposed changes. Okay, paragraph 22, agreement of parties. Third-party financing addendum wasn't marked. Oh, now we have another thing for the seller's invitation. Seller's temporary residential lease. No, paragraph 10 said it is upon closing and funding. Gotta have that removed. Next one is addendum for mandatory. No, in paragraph 6E2, it said that it wasn't subject to it. So they cannot be marked. And other, we better see a non-realty item addendum. Okay. So again, this paragraph has to be perfectly. This is how the contract extends past these number of pages between the parties. It adds an addendum. And it can also, if you're going to do it after an executed contract and the parties agree to add an addendum later, like the non-realty item, you better have an amendment that attaches it to the contract on paragraph 22 as attached. So again, you've got to learn to do these correctly because these are the agreement of parties and they are contractually binding between the parties. Okay. Consultant attorney, you better believe it. We're
Wait,
not lawyers.
Marilyn, quick question.
Mhm.
Again, can you explain why the mud disclosure is not under other?
Because it is not an agreement of parties. It is statutorily required for a seller
Uh-huh.
to provide these notices, but these are notices. This is agreement of parties.
Got
Not
it.
Mhm. Seller's
Thank-
disclosure should never be on here either.
Thank you.
Okay, so we just looked at that offer, right? So now we're going to go back to our PowerPoint, and now I'm going to talk to you a little bit about some of the issues that come up on various things. Okay. Okay. All right. Paragraph 1. Is it important? You better believe it. It better be correct. I cannot tell you how many offers I've seen, contracts, and they say the seller is owner of record. No, they have names. It's not going to be owner of record. It's going to be the actual names that show that they're the owner of the property. Every buyer has a right to know who the seller is and who is acting on behalf of the seller. In the example I gave you, Jane Doe is going to represent herself, right? And sign for herself for this contract. But the estate of John Doe, somebody who has legal authority to settle that estate is going to sign up on behalf of the estate. Big issues. You got to have all the clarity on this. The buyer Excalibur LLC and or assigns. Oh, that sends up a huge flag. We'll talk a little bit about what does it mean and or assigns. Just pay attention. Signatures, make sure they're signed properly. LLCs, trust, estates, they don't have hands, so they can never sign. So your signatory can't be Excalibur LLC. It would be, John Smith, comma, president, sole member of Excalibur LLC, whatever their title is legally. But Excalibur LLC cannot sign, period. Let's get this right. Now, here's some questions just from this one paragraph that are going to need to be answered, both from a seller standpoint and the buyer's agents better be prepared to provide it. So sellers would need to know, are the buyers owner occupants? Why is that? Well, because if they are, then there's other questions you have to ask for that. Are the buyers investors using the property as rental or a flip transaction? Well, that's a fact. The buyer agent absolutely knows that. Or is Excalibur LLC acting as a wholesaler? Big indication of that is it says and or assigns. Okay, and you have to know what that means, and your sellers have to know it. Now, see, if the buyers are going to be owner occupants, sellers need to know, do they have a property to sell, or are they tied up in a lease? Yep, you better have those in writing, because your seller needs to know that you've done a superb job in giving them all the data they need to make a good decision about acceptance of an offer. If the buyers are investors using the LLC, the buyer agent is going to confirm that that individual, John Smith, has legal authority. I have the articles that show that he has the authority. That's what a buyer agent would have to be prepared to say. Okay.
Carolyn, I have a question. Looking back at your 1 to 4 that you used as a sample with Jane Doe and the estate of John Doe, does Jane Doe need to initial and sign as both entities? And if so, how is that signature going to look? John Doe by the authority, or John Doe estate by the executor or executress of
They
the
have to be
estate?
the executor or the executrix.
Trust,
And they
right?
will sign Jane Doe, comma, executrix, comma, for the estate of John Doe.
Okay, and on the initials, can they just put JD or or JDE for the initials?
Yeah, I'm gonna
It's a
show
great
you.
question.
I mean, I understand on the signature part how that needs to be done, as the executor or the executress of
Look
the
at this.
estate. I'm sorry.
JS. Yeah, this is how the legal authority, it says JS for
JS for,
Excalibur LLC. That's how your parties would sign.
Okay. JD for. Perfect. Thank you.
Good
Okay.
question, Linda.
Mhm. Okay, so if buyers are wholesalers, a whole slew of questions need to be answered, and your sellers need something in writing. Well, you're going to review this with them. Putting it in writing will confirm that you did review this with them. See, if the buyers are wholesalers, the sellers need to know that they will be selling the paper contract, the equitable interest, and the buyer will be making money off their negotiations with the seller. That's what they need to know. The other thing they need to know, if they agree to the Excalibur LLC and or assigns, the seller has no right to approve the assignment if they allow this provision. And that's usually very critical for them. Remember, buyer agents, if you represent the buyer as a wholesaler, you are not involved in any assignment process other than maybe an amendment to the contract showing a new buyer, and the previous buyers always have to sign when there's an assignment to a new party. But who do you represent, buyer number one or the assigned buyer number two? Somebody take yourself off of mute and answer.
Number one.
Number one.
Number one.
Amen. Only number one. So here's what it means. We've had buyers agents number two that represent investors, right? The investor approaches the buyer agent number two and says, hey, I want to get the assignment of this contract from buyer number one, who's a wholesaler. So buyer agent number two says, that's fine, but if I'm going to work for you in my agreement, you have to pay my compensation. Because you're not on the original contract. That first buyer agent number one and their broker are on the contract, and that broker is going to be paid, not buyer agent number two. Buyer agent number two gets compensation from their buyer only. Everybody understand that? We've had lots of confusion on that. Okay. So paragraph 2, I told you, you better take the time to look at every T and cross every I, T and dot every I, because what we say in paragraph 2, that legal description, that's what the property that you're selling. So they're exchanged on legal description. If you screwed up and got the legal description wrong and the property address, you're in real trouble, period. I blame both agents. Because ultimately the seller agreed to it, and the seller would never agree to something that they didn't own, you would think. But their agent probably didn't cross the T's and dot the I's. Again, if there are going to be any improvements or accessories, just like we had in this one, where the chandelier and dining room will not be remaining, you have to cover that. Our best practice is we would always tell the seller to remove everything that they do not want to convey that's real property, so that when the buyer sees the property, both in my professional photographs and when they walk in the door, that's the property they're willing to accept in that condition. Again, if they have any exclusions and you didn't do it the way I recommend, they have to have those exclusions out of the property prior to delivery of possession, and that's at funding, right? We've had way too many sellers who thought they could go close. By the time they got to the property, it had already funded. They had no right to be on that property. I don't think the listing agent told them to go back and do that. I'm hoping they didn't, but that could be.
Unless they have a lease back, right, Marilyn?
Yeah, that's the only way, and we talk about that in paragraph 10, possession. The only way they have the ability to remain in the property after closing and funding is with a seller's temporary residential lease, and the only way the buyer will go into the property prior to closing and funding would be on a buyer's temporary residential lease. Now, paragraph 3, we talked about this. 3A plus 3B equals 3C. If it's cash, you better have proof of funds that are in the possession of the buyer on the contract. And seller should probably get a conditional approval letter. These two things are your best practices, right? Here's where we had a problem. We had a seller who sued not only their listing agent, which was their friend, but also the buyer agent, because they kept wanting a proof of funds for a cash transaction. It wasn't coming. The listing agent said, I don't have it yet. I've requested it. Buyer agent said, buyer, blah, 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 right? And the seller said, I want to sign the contract anyway. What the listing agent did not have in writing is, I've told you, I don't want you to go forward until you have proof of funds. They haven't provided it to me yet, but you decided not to take that advice and you want to go forward with the contract. Better have that in writing. That other agent did not have it. They went after the buyer's agent because the buyer was a flake. Seller went out, got a rental property because their big home was being built, incurred a ton of expenses, and they got all that money from not only the listing agent and broker, but also the buyer agent and broker for having a fraudulent buyer. Now, paragraph 4 is real clear. If there's a current tenant in the property at time of offer, you must attach the addendum regarding residential leases. That was not on paragraph 22. Again, that long list that the listing agent had is saying, oh my gosh, this buyer really doesn't know how to put an offer together. Now the seller is going to send back an invitation and tell them all the corrections that have to be there. If there are any fixture leases, and truthfully, a listing agent should know this. Yeah, you better know it at time of taking the listing. But many times it's in the seller's disclosure, and the buyer agent didn't look at it and add the addendum regarding fixture leases regarding that item. And a lot of it could be, the satellite dish, all these different leases that they have, security leases, all these different things.
Yeah. I
That,
just lost one on I just had to correct one on a security system that was leased. So
yeah, it's a big
thanks for
thing.
catching that.
You need to catch it at time of offer, because if you don't, neither party has to agree to anything, right? And it causes a major problem. And I blame the listing agent and the buyer agent. They know better than this. That's their job. Paragraph 5, again, the escrow agent is title company only. While earnest money is not required, most sellers that I see on our contracts want some skin in the game by the buyers, right? Listing agents, you really need to verify with the buyer agent, how does the buyer plan on depositing the earnest money and option fee? Why? Why is that important? Well, it's the buyer's agent's fiduciary duty to deposit it for the buyer. Okay, and we have lots of situations that aren't going on very well. So a listing agent could ask that. Based on what they're saying, they'll go back to the seller. Look, I don't think they know what they're doing because I can't get an answer out of them. The other thing that's come up regarding the deposit of option fee and earnest money. Can a seller block a buyer from doing an inspection if the earnest money and option fee are not receipted? Yes or no?
No.
Yeah.
Absolutely not. It's paragraph 7A of the contract. Learn your provisions. If the listing agent is professing that they're interfering in the buyer's contract, the buyer could just say, let the listing agent know paragraph 7A of the contract will prevail. If you continue to interfere with the contract between the seller and I will have to get my attorney.
Wow.
Amen. That's a legal dispute.
Wow.
We don't resolve those, and we don't cause the problems. So listing agents, if you're doing it, you're going to stop immediately.
Yes, because the contract is still in play. It's just that the terms are out of play.
Well, the option fee may not be a part of the issue. And therein lies the problem. We have sellers who haven't been told that the buyer has not deposited even the earnest money for the contract terms. Sellers can't terminate if they don't deposit the option fee, or if the option period has passed and the buyer has failed to get it receipted. So there's lots of problems both for buyers, agents, and listing agents if you do not pay attention to the provisions in this contract in paragraph 5. Okay, if the option fee is not receipted within 3 days of the executed date, buyer has no option period, but there is still a contract between the buyer and the seller. Buyer just doesn't have the unrestricted right to terminate. That's the job of the listing agent and seller, to give that notice to the buyer. Title company is not going to do that. They're instructed in paragraph 5 to first put all monies to the option fee and then the remainder to earnest money or additional earnest money. The only provision in the contract for a seller to terminate if buyer fails to deposit earnest money for the contract. So that is important. And we've had too many sellers who found out from their listing agents that they could have terminated the contract because the buyer failed to deposit the earnest money for the contract. But because the seller had not terminated the contract, they didn't do that. And then the buyer came in on day 6 and put in the earnest money and option fee. Well, they don't have a termination option, obviously. And the seller is too late to be able to terminate the contract because they did not terminate before that earnest money was receipted after the terms of the contract. Pay attention to this deadline, listing agents. That will prove that you have failed in your fiduciary duty to your sellers. And buyer agents, you better make sure that that option fee and earnest money are deposited per the contract and never use the termination option provision in paragraph 5 for a notice of buyer's termination. If the buyer has failed to deposit it per the terms of the contract, you know what we're telling our sellers? Go after the buyer agent and the broker. They don't know what they're doing. That buyer did not have the unrestricted right to terminate. They did not pay for that option fee for the terms of the contract. And now they've given us a notice thinking they do. Well, the buyer's going to turn on the buyer agent and the buyer's broker. So do not be negligent. Sellers are going to turn them into track because they don't know how to use the promulgated forms. Everybody knows that you don't get an option unless you pay for it. Buyer gives the seller, the title company will receipt it, an option fee. Now the seller will give the termination option to the buyer, but until that's done, buyer doesn't have one. We have way too many agents that are making big mistakes on this. Now, paragraph 6A.
Sorry,
Yes.
Mel, would you repeat that? On the option money that I'm sorry, it didn't register in my brain for some reason.
A buyer does not have a termination option unless they paid for the option fee per the terms of the contract.
Right.
Buyer has to pay for it per the terms of the contract for the seller to give it to the buyer.
Okay, but if they come back and pay after the 3-day option,
Doesn't
then
work that way. The seller will send a message saying, well, we still have a contract. You do not have the unrestricted right to terminate. You failed to deposit the option fee per the terms of the contract.
and how does the seller notify the buyer of that?
How does any seller notify a buyer of anything? They go through the agents.
Well, obviously, but I mean, there's not a document that
No,
we use for that. It's just notice from selling agent to buying agent that you need to advise your buyer
from the
that they
listing
failed.
agent per their seller's instructions to the
Yes.
buyer agent.
Okay. Thank you.
You're welcome. 6A, the seller and buyer, in the example I gave you, they didn't mark a box, so there's a real serious issue already. We don't know who's going to pay for the title policy. It's negotiable, but the parties have to mark a box. Title company's going to have the commitment within 20 days. Typically, it's hard coded in our contract forms now. So make sure you read all the schedules and you make sure your buyer reads all the schedules. If they have any questions, contact the escrow officer at the title company. That's probably the best way to get better clarification on it. 6A, these are shortages. In the example I gave, the buyer wanted it to be amended to include the shortages, and they wanted seller to pay it. If the sellers are willing to do that, you just need to know how much it is. If the seller says, I'm not paying for it, I'm marking the buyer box, buyer will find out from their agent how much that premium endorsement will cost, and then they'll pay for it. In paragraph 6C, we talked a lot about this because I'm scared to death of agents being caught violating copyright laws. So again, if 6C is going to be done, the listing agent is going to vet that the existing survey is in the seller's name. It does not have a copyright protection, and it does not have a notation by the surveyor that it could have only been used for that prior transaction only. They will have in their possession the sworn notarized T-47 affidavit and a copy of the existing survey, because they have to provide both within those number of days. Otherwise, the buyer gets to get a new one. Okay, usually listing agent will have to pay for that one. 2 is where buyer will obtain their own survey and pay for it. And 3 is where the seller will pay and obtain a new survey. So, you know, buyer's agents, your script is always going to be, we always recommend that you get your own survey. Using an existing survey does not provide you that. It's not your survey. It's only for title and lender purposes. Okay. So again, listing agents, don't pass along a copyrighted survey. Don't pass along a survey that doesn't have your seller's name on it. And don't pass along a survey that the surveyor put a limitation of the previous transaction only. Real clear. And it's always on the survey. It's easy to see that. Now 6D, those objections, we had residential rental, we had a daycare facility and a healthcare facility. Sellers need to know, will there be an issue with that buyer performing those activities on the property? They need to vet all of that and get that all taken care of. Okay, that's what their job is, to do that. In 6E, again, there's only 6E2 where we see a notation about mandatory membership in a property owners association. Remember, all these assessments or taxes are always the obligation for a buyer to pay it. And if they don't pay them, they could be in serious trouble. It could be that they could be foreclosed upon, which is not a good option to do. Now in paragraph 7, which is property condition, paragraph 7A, that's the part where listing agents think they hold court and say, you don't get to do your inspections till you receive the option fee or earnest money. No, that's not true. Okay. It says sellers at seller's expense shall immediately cause existing utilities to be turned on and shall keep utilities on during the time this contract is in effect. Now here's what is a big issue on this. Listing agents rely upon the sellers to tell them the truth, don't they? If I were you, in my listing and special provisions, you would add that the sellers acknowledge all utilities are on at the property and will remain on through a term of the contract, period. When you put it in the listing agreement, now if the seller says they're all on, it's all on the seller, not you as the listing agent. A lot of people blame the listing agent, and the listing agent's just what? Relying upon what the seller has told them. And then the buyer reschedules to go out there and the gas is still not on, or the water's not on because the tenant before had a huge bill and the landlord hasn't paid. All these different kinds of issues come up with utilities. It really is a part that kind of pulls the agents into this big, huge thing. So in this 7A, it says that buyers at reasonable times have a right to inspect the property or buy a truck inspector, or those that are licensed to inspect. So it's at reasonable times. It doesn't say only during the termination of, and it doesn't say you can't do it a day before closing, all of those types of things. Yes, you have a question? Take yourself off mute and ask.
Yes, Marilyn, can you say that again? I was going to write it down. You said that I can put in my listing agreement for my seller to kind of initial.
Yeah, that seller will have all utilities on the property and will keep them on through the course of the contract term.
Or we can just simply say through closing and funding, right, Marilyn?
It could be. Mhm.
Okay, perfect.
Thank you.
Whatever the sellers understand in writing. In my listing agreement, I'd also have them initial that special provisions, because then it would look like I didn't insert it and didn't go through it with the seller. Okay, lots of times we have to kind of do that to bring their attention to something like that. And you know what? We have had sellers who absolutely knew they couldn't put the utilities on because they had a huge bill that they hadn't paid, and they're not truthful with the listing agent. And then it pulls the listing agent into a dispute because the buyer agent said, well, you told us this. You know what I'm saying? We went out there and reinspect all this kind of stuff. I hate that. Could easily be avoided if the sellers did what they had agreed to in the contract.
Yes.
In 7, there's lots of provisions. I showed you the ones that are coming, but even without those new languages that are added to 7F, you better have a receipt, paid receipt for every repair or treatment the seller is asked to negotiate. Now, in 7B, it talks about the seller's disclosure. There are only 11 exemptions, and never having lived in the property or being a flipper or investor are not exemptions. I'm so tired of other brokerage not helping their sellers comply with the law. That's really gross negligence, truly gross negligence. In 7D, in the offer that we had, they marked both boxes. They can't, they only have to mark one. And the as is in paragraph 71, I've heard listing agents in text messages and emails back to the buyer agent. This is an as is, the seller's not going to negotiate with the buyer. Well, that's not true. It's as is what the buyer knows at that time. Doesn't say they can't negotiate with the seller. They can negotiate with the seller until the day of closing. And when agents really misunderstand, misinterpret provisions of the promulgated form, they are going to be in trouble. It's pretty simple for a buyer to feel like they could easily file a complaint because of the types of things they said. A lot of listing agents are really foolish because they put things in writing. They're making big mistakes and they're saying things in writing to the buyer agent. The buyer agent says, hey, I'm sharing this with my buyer. So,
Marilyn, pardon me again. So on that as is statement, so if they have reviewed the seller's disclosure and the seller is advising them that there is something that's in defect on the property, then this as is means that the seller is not obligated to do that repair. I mean, I know they're not obligated to do any repairs, but that's
what it
where
means
that-
is that the buyer has accepted it. They have knowledge of it and they accepted it. Doesn't mean they won't go back and negotiate it.
Right. So if there's something that's in the seller's disclosure as a buyer's agent, I would want to list that instead of in the as is as specific repairs to be completed as part of this contract.
That's what a good buyer agent would do.
Right.
7D2 is important. If a buyer knows something, they've accepted it. Therein lies the problem. That's how our language in this part of the contract changed. And in my office, I was the risk manager of the office that was a part of the lawsuit. And it proved that the buyer was in trouble because the buyer knew about these conditions. The buyer agent had put it in writing. You really need to get somebody out here to further investigate your foundation as the inspector recommended. That buyer agent was so good. He put in detail everything that the buyer should do. The buyer came back and said, no, that's okay. That's no big deal. My son said, no, 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 all these things. And then a year later, they sued us. We got out of the lawsuit right away. They kept the listing agent and the broker and the sellers in it. And then on appeal, the sellers lost. The buyers lost. Listing agent prevailed, broker prevailed, and sellers prevailed. Buyer knew something. They're tasked with either negotiating in 7D2 or an amendment in the contract. But if they accept it, they don't have the right to come back later and sue for it. Big important things. And 7D2 is where you would put it. The word professionally means a whole lot. If you just say clean the property or broom, some agents are using broom sweep condition or whatever. I don't know about you. Some people don't even own a broom. So how could you do something like that? Be more specific about the real condition your buyer wants to have.
Marilyn, you know that's no ROI term, broom swept.
As I said, some people don't even have a broom. So that's not how you would want. It has to be defined, and professionally means I know the difference between somebody who is a professional home cleaner versus a professional landscaper too. There's just big differences on all of these things. So be specific. Just as an aside, a lot of buyers stripped out so much trying to win the property in a contract. We
Yes.
had buyer's agents who failed to tell the buyers, while you didn't negotiate in 7H with the seller to reimburse you for the residential service contract, I still recommend that you get one. If they say, I don't want one, that's fine. You keep whatever that communication is so they can prove that you did advise them properly. In paragraph 8A, the Excalibur LLC said that they were a license holder in the state of Texas. They're required to do so. Please, please do not put anything about commission in this contract. That's not where it belongs. They're in separate agreements, but don't put it in the contract. The commission is going to be paid by one party or another. Now in the closing, it's real clear. It doesn't have an automatic extension if the lender is not ready to close, right? Do buyer and seller always have to say yes to any closing extensions? Yes or no?
No, ma'am.
No,
Wow.
they don't.
No.
Did somebody say why?
Yes, somebody said why.
Yeah, the problem is on paragraph 9, it says that the party that doesn't close by the closing date, the other party gets to look at paragraph 15 default. If the parties do not mutually agree to extend the closing date, it's not extended. Now, the buyers could get an attorney and come after the seller and say, you know, all these different things. Well, then the seller has to hire an attorney. All those kinds of things can happen. But bottom line is nobody's forced to ever agree to something once they've signed an executed contract. It has to be mutually agreed upon. Paragraph 10, those are those temporary leases we talked about. In our offer that we analyzed, it said upon closing and funding. And that's exactly what it means. At funding, the sellers are not going to go back to the property unless they had a temporary residential lease. And buyers don't go into the property prior to closing and funding unless they have a buyer's temporary residential lease. Now, in paragraph 11, you have to be very careful. All factual statements, they come from our clients only. And if there is a conflict or dispute, you're going to have to point it out. Now, this is in dispute to paragraph 7A. And so they're going to have to get a legal counsel to help resolve that. So again, if a buyer's agent is offering a concession to the buyer, the seller needs to know that. Plus, the lender has already approved it or should approve it. You don't put it in there unless it's subject to the lender approval and they've already approved it. And it will be on the contract and special provisions or in an amendment. And all amendments go to the lender. So there's nothing you're hiding from anybody. Everybody knows it and they should know it. They have every right to know those things. On paragraph 12 in the offer that we provided, the buyer didn't negotiate any of the seller's equity, but that's what it's doing. Do not use this paragraph for cash transactions. We've had lots of agents who did not do the right thing here. These are settlement expenses that would be incurred because there is a third-party lender involved. Paragraph 13, we showed the prorations. The house and all the charges are the seller's expenses through the day of closing. So make sure your net sheet is done properly on something like that. I did point out paragraph 19 representations and about how you need to bring it to your seller's attention. And paragraph 20 about FERPA, very serious matter. Sellers need to handle it perfectly. Buyers need to know about it before the offer. Usually the good listing agents will put it in agent remarks, seller is subject to FERPA and that type of thing. In paragraph 21, notices, it can never be blank. As I said, it's how you deliver a notice to the other party. Notices are those things that are required because per the contract, time is of the essence. Buyer's notice of termination, seller's notice of termination, right? Those types of things are critical. Your buyers and sellers have to know that, hey, if the other party keeps contacting you, you tell them, please stop, go through my agent only. Pretty simple. That's what they should be told. It's not for discussions outside of anything. It's for notices. Paragraph 22, that's the agreement of parties. I talked about the addenda that would need to be there. Do not add an IABS. Do not add seller's disclosure. Do not add MLS printouts. no notices that are attached to the contract because of paragraph 6. E. So again, just be real careful. If you add something after the executed contract, you have to do it with an amendment to add it to paragraph 22 and then have it attached and signed by all parties as well as the amendment. Now, paragraph 23, those are for the attorneys, right? Please stop putting buyer's choice and seller's choice. Those are not the names of the attorneys. Please, please, please stop putting silly stuff in there. Now, the last thing is on paragraph, page 10. Page 10.
Carolyn, pardon me, I have another question that just came to mind. If my client is an attorney, do I need to put in there self?
I don't think so.
Okay, because I have been.
Yeah,
Because
well,
I feel like the other party needs to know that my client's an attorney.
yeah, I think all parties need to know that. If the
Yes.
buyers are attorneys, they need to be told that as well. Some attorneys are real sensitive about that. I'm surprised that they would do it. I don't have a problem with it. It's usually someone that the seller is being represented by. The seller is the seller on the contract. They have like a dual role. No, I don't think so. But I do believe all parties need to know if there's attorneys involved that are principals in the transaction.
Yeah, I do. Well, I do too. That's why I've always said that the
But
buyer's
As
attorney
long
are-
as long as your clients are okay with it, there's no
Oh, yeah,
problem.
they were.
Now, page 10 is broker information. Nobody gets to sign it. It's not a part of the contract, but it better be correct and it better be completed. It's a violation of TREC not to have all the information correct. The licensed supervisor, their number, your name, your number, the brokerage name and the brokerage license number. All those parts have to be completed. And they think what we do is easy. They really do. And I can tell you that we run into so many issues every day as realtors representing our clients that they have no idea what you have to know in order to make sure that you fiduciarily represent your client properly. The biggest problem I have is when agents pop off and say things that are insightful, that say things that are not true, a part of the contract between the parties. You know, they're making up their own rules type of thing. I have a real dislike for that type of thing. That paragraph 7A, all these listing agents saying you can't do your inspections until you get all this received. That's not a part of the contract. And if the seller wanted to put that in the contract and it conflicted with 7A, then the buyer's going to hire their attorney to advise them, because we would never say that's okay. The promulgated form, we have to uphold it. We don't get to say, don't pay attention to it, let's change it. No, we don't get to do all those things. We are tasked with upholding and using the promulgated forms. Okay, we just have to know when to tell our clients you need legal help. Doesn't say Keller Williams Law Firm. It's a real estate operation. We help buyers and sellers and landlords and tenants, and we do it quite well, much to the chagrin of a lot of other brokerages. So
You
again,
got that right.
right, and I know, because the only people who know that you violate advertising rules are other realtors and other agents. Most people are not over there trying to verify that you've done all the right things. But man, if there's somebody gunning for you in your development because you tend to have more signs than they do, they are the ones that typically turn you in for violations. And it takes your great time that you're usually spending to help others in trying to justify what you did and how you did it and those kinds of things.
Marilyn, with that being said, on that note, I'd like to share that one of our agents was just fined by HAR $1,000 by putting a sign in the yard and not having the listing in HAR within 24 hours. So you don't think that was another agent that reported him?
Ha,
Huh,
yeah,
yeah,
that's a violation. Remember when you,
that's $1,000 fine, not a
Yeah.
warning, first offense,
oh no,
1,000.
yeah. And again, HAR is very clear on clear cooperation policy. You don't get to put a sign in the yard without having it in MLS within 1 day.
Mhm.
So it's very important. What we're going to do next month is go through analyzing addenda, because while we use some addendum more often than others, like third-party financing addendum, we're going to go through where the issues are and looking at various addenda and the way that they're completed and how we would analyze them. Again, they have to be perfect. Because TREC is going to change so many of them, we'll be doing it, once they approve it, we're going to be doing it based on the new forms, okay? Which I'll point out how the current forms may be changing based upon the provisions for the proposed changes. But again, we have to be very careful with these addenda. They are part of the contract. They're legally binding. And unfortunately, under oath, sellers and buyers say, oh, no, no, the agent never explained it to me. I had no idea what this meant. They just shoved it over and told me to initial sign and date. So we know they'll turn on you in a heartbeat. While you may have verbally said it, you have to have proof that you actually did it, okay, on something like that. So that's what we're going to do next month. And before November's meeting, we'll be meeting after they've already approved the form. So when we have our November meeting, we're not going to know that we're going to be pushing to do all of our training in December, and we'll continue on next year because everybody needs to be certain about the new forms and the revisions. But I am going to talk to you a little bit about something. In your region, the TREC still keeps track by region within the state of Texas where the majority of the complaints come from, right? And part of them, the biggest count, is the breach of contract. And that includes false promise. And so I'm going to talk to you about what a false promise is, because unfortunately, it could be where you would shrug your shoulders as a listing agent and tell a prospect, better put an offer in now because it's going to go fast. That's a false promise. You'll be in serious trouble. So again, there are lots of little things and nuances that are coming forward, but when TREC identifies the majority of the complaints, the breach of contract, the false promise, the misuse of intermediary, which it's misused so badly, it just makes me cry, because they can take away your license and the broker's license if you are found in violation of it. They have lots of different stringent requirements for following intermediary from the broker's perspective, but also if a sales agent does it per TREC. So we'll kind of touch upon those by the time we're getting ready to have all the forms approved and that we know that we have new ones to use. All right, good people, please have a very safe and dry, maybe Labor Day. And remember about the sellers' temporary residential leases as of this Thursday, as well as the buyers' temporary residential leases. Take care, everybody.
Marilyn,
Thank you.
Thank you.
Thank you.
Thank
You're
you.
welcome. My pleasure.
Thank you.
Thank you.